Hello and welcome to SANDEMY. This series explains housing law, standards, and the Renters' Rights Act in clear, accessible language, without getting lost in legal jargon or headlines.
We're not here to give legal advice or take sides. Instead, we focus on how the housing system actually works in practice for tenants, landlords, letting agents, and local authorities.
In this episode, we're looking at what is the Renters' Rights Act, and why does it change renting in England, and why it matters in the wider context of renting in England.
Let's get started.
Okay, so to begin, the Renters' Rights Act seems to be everywhere at the moment. It feels like this massive, almost overwhelming topic.
It is.
So why are we talking about this right now? Why is this the moment for such a big conversation?
That's a very fair question. And to understand why now, you really have to look backward before you can look forward. We have to set the scene.
Okay.
For over 30 years, the private rented sector in England has operated on a very specific framework.
That takes us all the way back to the Housing Act of 1988, doesn't it? That was a completely different time.
Precisely. A completely different era. And to get the new act, you have to understand what the '88 Act was trying to do.
Right.
Before that, renting was very different. You often had strict rent controls, lifetime security for tenants. The 1988 Act was all about deregulation. The goal was to invigorate the market.
To get more landlords into the game.
Exactly. To encourage people to become landlords by giving them a really easy exit strategy.
Right, so the logic was something like, if we make it easier to get a property back, more people will be willing to rent them out.
That was it. Exactly. And that framework was built around short-term tenancies, specifically the fixed-term assured short-hold tenancy.
The AST.
Yes, it was designed with limited security of tenure in mind. And perhaps most importantly for this discussion, it relied on a largely reactive enforcement model.
When you say reactive, do you mean how local councils police the standards, sort of waiting for things to go wrong?
Essentially, yes. The model was to wait for a complaint to be made, for a dispute to arise, before anyone stepped in. It wasn't built for proactive monitoring.
It's a bit of a catch-22 then, isn't it?
How do you mean?
Well, if you're on a 6-month contract and you complain about damp, you might just worry that the landlord won't renew your tenancy. So, silence becomes the safer option.
That is exactly the friction we saw. And you also have to look at how the people living in these homes have changed. In 1988, private renting was often a short-term stopgap.
For students or young professionals?
Yes, transient. People moving to a city for a year or two before buying.
Whereas today, it's a totally different picture. You have families raising children in rented homes, older people renting long-term.
Exactly. The legal framework was sort of frozen in 1988, but the reality of who was renting evolved massively. And this leads to what we call the widening gap.
Okay.
Over the last 30 years, the gap between what people actually need from a home and the legal protections available and, the capacity for enforcement, it just grew too wide.
So the act isn't just a new rule out of nowhere. It's an attempt to reset a balance that's been off for a very long time.
That is the core context. The Renters' Rights Act is intended to bridge that gap, to align the law with the modern reality of renting.
Okay, that sets the stage perfectly. So let's move on to the act itself. I've heard it described as a generational change. It sounds a little dramatic, doesn't it?
It might sound it, but in housing law terms, it's pretty accurate. This is structural reform.
So we're not just talking about a minor amendment here.
No, not at all. We aren't tweaking a notice period by a few weeks or changing a small definition. This is a complete redesign of how renting works.
So it's a redesign of the engine, not just changing the tires.
That's a great analogy. And if you had to pick the single headline change, the one thing that really signals this redesign, it's the removal of fixed-term assured short-hold tenancies.
Wow, okay. That's the standard contract almost everyone who rents or lets a property knows. You sign for 12 months, maybe a 6-month break clause. It's the default.
Correct. And that is going away entirely. The Act replaces all of that with a single system of periodic tenancies.
I want to pause on that because periodic tenancy is a term that, housing officers will know, but maybe not the average listener. Can you unpack that?
Of course. So in the old model, you had a start date and an end date, a fixed term.
Right.
You knew that unless something went very wrong, the tenancy would exist for that block of time. Both sides were locked in.
And at the end of that period, you'd have that sort of renewal dance. Do we sign for another year? Does the rent go up?
Exactly. There was a built-in churn point. Under the new periodic system, there's no fixed end date from the start. The tenancy just rolls on, usually monthly, indefinitely.
Indefinitely.
It just rolls on until the tenant decides to leave or the landlord has a valid legal reason to end it.
So it's a shift away from that automatic turnover. It sounds like it changes the whole psychology of the agreement.
Precisely. It ends that routine churn. And because you're changing the very basis of the agreement, it has this massive ripple effect.
How so?
Well, it changes how tenancies can be ended. It changes how rent increases are regulated. It changes how disputes are resolved.
So it really does sound like it touches every single part of the life cycle of a rental home.
It does. It's a fundamental shift in the mechanics of the sector. The whole assumption shifts from this is temporary to this is a home.
Let's break this down then, for who it actually affects. Let's start with landlords. If I'm a landlord, hearing no fixed term probably sounds quite daunting. It sounds like losing control.
And that anxiety is understandable. But the shift is really about moving away from that routine turnover and towards, well, we call it evidence-based tenancy management.
Evidence-based, that sounds very formal. What does that look like in practice?
Well, previously, a landlord could often end a tenancy just because the fixed term had expired, or by using a no-fault mechanism like Section 21.
Yeah.
You didn't need a reason.
Right. It was an administrative process, not a reasoned one.
Exactly. Under the new act, ending a tenancy becomes a much more structured, regulated process. You can't just wait for a date on the calendar. You have to have specific grounds.
So, valid legal reasons.
Yes, and you must provide evidence for those grounds.
So let's say I want to sell the property. That's a valid reason, right?
Yes, selling is a valid ground. But you won't be able to just say, I'm thinking of selling to get the tenant out. You'll need to evidence that.
Like showing the estate agent's contract.
That's the sort of thing, yes. Or the solicitor's instruction. You can't just use it as a loophole to evict a tenant and then re-let the property a week later at a higher rent.
I see. And I assume there would be penalties for that.
Significant penalties. It demands a much higher level of professional management. It really removes the ambiguity.
Now let's flip the coin. What does this reset mean for tenants?
For tenants, the Act is designed to provide three main things: greater security, clearer rights, and stronger routes for redress.
Security is the big one, isn't it? That fear of the Section 21 notice landing on the doormat has been a huge talking point for years.
It has. The shift to periodic tenancies means there's no fear of that arbitrary eviction. A tenant doesn't have to worry that just because their contract is up, they might have to move for no reason.
It lets them put down roots.
A greater sense of home. You can buy furniture that fits. You can register your kids at the local school without worrying you'll be moved miles away in July.
And redress. That's a word lawyers love, but what does it actually mean for a tenant with a broken boiler?
It means having a referee. The Act introduces a new ombudsman for the private rented sector.
So, an alternative to going to court.
Exactly. Previously, the tenant's only real options were the local council, who are often under-resourced, or the courts, which are expensive and slow. An ombudsman provides a free, impartial dispute resolution service.
It seems like for both sides then, it's really about removing ambiguity. The rules are just clearer.
That's a very good way to put it. It removes the gray areas where so much of the anxiety and friction in the current system comes from.
Now, there's a third group here that often gets forgotten. The local councils. The housing officers. Is this just a mountain of new paperwork for them?
It's easy to assume that, but no.
Yeah.
It isn't just an increase in work. It's a change in regulatory responsibility.
What does that mean for the officer on the ground?
Remember we talked about the old system being reactive?
Waiting for complaints.
Yes. The Act shifts the focus from reacting to complaints to monitoring long-term compliance. And the key to that is data.
Data. You mean knowing where the rental properties actually are?
Exactly. A huge challenge for councils has always been visibility. The Act introduces a new private rented sector database.
So a digital register of all rental properties.
Yes. All landlords and properties will need to be on it. This changes the game for enforcement. It allows councils to see who is renting what, to shift from fighting fires to fire prevention.
And does this help with that uneven enforcement you mentioned, the thing that frustrates good landlords?
That is absolutely the aim.
Yeah.
By creating a system where compliance is monitored more systematically, it helps to level the playing field.
So if you're a good landlord, you shouldn't fear the database. It's there to make sure your competitor is meeting the same standards.
Precisely. It professionalizes the oversight in the same way it professionalizes the management of the tenancy itself.
We've covered a lot of ground. Before we wrap up, could you summarize that generational change idea one last time? What's the one thing people should take away?
The core message is this. Previous reforms tinkered with the engine. They added a requirement here, a safety check there. This act changes the very foundations.
It's pouring new concrete.
It is. Once this is fully implemented, the private rented sector will no longer operate on the tenancy model that has existed for decades. The default assumption of short-termism is being replaced by an assumption of stability.
That's a huge statement. So why do we need to understand this right now? I mean, some of the regulations are still being finalized. Why not just wait?
Because culture takes longer to change than law. While the act itself is the primary legislation, there will be lots of secondary legislation and guidance to come. But we can't wait for every single detail to be printed before we start to understand the shift.
So don't wait until the law is knocking on your door to figure out what it means.
Precisely. The expectations on landlords, the protections for tenants, the role of councils, it will all be fundamentally different. Early understanding and preparation are absolutely essential.
It's about not getting caught out when the tide turns.
Exactly. And just a reminder, keeping up to date is vital. The framework is set, but the fine details will continue to emerge.
That brings us to the end of this episode of SANDEMY. We hope this has helped explain how this part of the housing system works and why the changes matter in practice.
This content is provided for general educational purposes only, does not constitute legal advice, and is not published on behalf of any local authority or organization. For specific situations, always refer to the legislation or official government guidance.
If you'd like to follow the rest of the series, you can subscribe to the channel for future episodes. In the next episode, we'll look at how renting and eviction will work under the Renters' Rights Act.